Okay, so let me make sure we're recording. And like I said, we have a lot to cover today, so we will kind of jump right into it and make sure that we have time to get through everything. We'll do introductions in a quick second here, but let's just start here. I want to put up a quick poll. We had incredible registrations on this. This is a hot topic in the HR industry, so appreciate you guys spending the 45 minutes that we have here today. But Ben, throw up this poll. I'd love to understand, just so that I'm speaking correctly and Kim and I know how nerdy to get with you guys about I-9. Where are you coming in with your I-9 knowledge at this point? Like, I'll say intro level is like, I understand section 1, section 2, whose responsibility those are, versus level 400 is like, I want to talk about TPS statuses and a bunch of the stuff that's been changing and regulating there. That'll help us understand how much to cover on this. Okay, really helpful. It looks like we got some pretty advanced I-9 people here. Ben, you can go ahead and end that poll and maybe pull it up so Kim can see it as well. Let's share the results on that so we know kind of where we're all coming in. Our goal today is to maybe clear some of the rough waters that have been happening here in the I-9 space, and make this all a little less scary. So regardless of where you are currently on your I-9 knowledge, hopefully you'll be a lot further on stuff after today's session. Just some quick introductions. I'm Chapelle Ryon. I'm CEO here at WorkBright. I have been in the I-9 space for a decade, consider myself fascinating dinner company, a great I-9 nerd who spends kind of all day in this space, particularly lately with all of the changes that have been coming. Kim, can you go ahead and introduce yourself as well?
Yeah, absolutely. Good to see you, Chapelle. I'm Kimberly Best-Robideaux, and I've been in this space starting out as a paralegal in the 90s and having an attorney show me how to do the I-9. So I totally geek out on it, just like you, Chapelle. Great dinner conversations. And I guide employers through those tricky questions and also the easy ones that aren't so easy with I-9s.
Awesome. Thank you, Kim, for being here. Okay, and we're going to do this a little Q&A format. I'm going to be kind of like moderator, but also sharing some stuff and then bringing Kim in to answer questions because, like she said, if I'm a 400 level, she's PhD level. So we will get to go super deep into all of this stuff and we'll be queuing up some topics. The way we formatted this is we're going to talk kind of in 3 sections. We're going to talk I-9, E-Verify, and TPS. And we're going to talk about some of the things that are happening there, and then we'll have a wrap-up slide to give you some action plans and some things that you can do. Hopefully at the end, we'll have time for Q&A. I talk really fast, so hopefully we can get through a lot of this content today and leave space. If not, we are collecting all of those questions, and we're happy to follow up with more specific guidance if there's specific use cases that we want to discuss. So let's jump into it. Starting here with our Form I-9, let's talk about some of the heightened enforcement that's been happening here. We have at WorkBright, there's been 5 executive orders so far that have been issued that I think like kind of come into our space that are kind of adjacent to what we're doing. But there's one in particular that's really meaty, and it was issued in January around intensified workplace enforcement. So Kim, tell us a little bit about what was in that executive order and how you're seeing it as like kind of this bright light, red flag, depending on how we're talking about it, in regards to our I-9. So specifically the executive order in January that was issued around intensified workplace enforcement.
Yeah, so that executive order essentially told the government agencies to focus in on enforcement efforts. So one of those enforcement efforts is the Form I-9, right? Because the government wants to make sure that employers are not only completing the form, but ensuring that those who are working at their work site are authorized to work and have the appropriate documentation. And then there's in that executive order, there's other pieces of enforcement, for H-1B, the FD&S site visits. For F1 STEM OPT, there's the audit files that could result in a visit from ICE, from SEVP. So it really focused in on, hey, employers, get your audit files and your I-9s in compliance because we are going to be focused on sending our agents out there to investigate, do inspections, and find out if there are any primarily undocumented workers that can be caught up in this big deportation event right now.
Absolutely. And not just we're going to be sending out our agents, but we're also going to be hiring more agents. That was a big piece of this, was increasing the workforce that is out there, enforcing some of these things and conducting those audits. And I kind of skipped over disclaimers in our intros, which I shouldn't have done. I just want to say, as we're talking through some of these issues, there's a lot of specifics. Something that I've been seeing with a lot of our customers is we have general counsels at organizations that are suddenly very interested in the I-9 processes and are jumping in, trying to understand what's happening there. And I just want to tell you, if you are one of those, thank you. We're glad to have you involved in the I-9 processes, but there's a lot of edge cases here. The information that USCIS puts out, I would say, largely covers the happy path. And then all of the following uncoverings and ICE audits and different things that kind of layer onto there are where things get really specific on this. And this world is changing so fast. I also want to say, we'll be running this webinar again in 5 or 6 weeks, and our recommendations and things that we come out with may be different based off of what's happening here. I did a podcast at the beginning of this year in January as administration was coming over before this EO came out and said, look, the administration campaigned on immigration. This is going to be a focus. I think audits are the first step, and I think that raids are going to be coming later just because they're more complicated and more, they take more time to put together. Well, that turns out to not be so true. We are seeing the raids start to pick up. So already from January to March, my recommendation on that, or the way that I'm speaking about it, has changed slightly. There was a really interesting one that just happened in Spring, Texas, where an audit uncovered discrepancies in the Form I-9s, which then led to a raid, which detained 20 individuals. So I think that the idea of audits, raids can go hand in hand, and we're seeing that. And the raids are starting a little faster than I maybe thought. Kim, you just put together a webinar with WR Immigration, which highly recommend you guys follow their webinars as well, specifically about what to do in the instance of if someone shows up for an audit or a raid. Can you give us kind of a high level overview? I know that you spent a whole hour talking about this on your webinar, but give us a high level of if someone's showing up for an audit or a raid, an ICE agent, what should employers do?
Yeah, so as you said, there's 2 separate things that we're looking at with ICE right now, right? And one is those normal or regular notices of inspection where ICE is coming and saying, hey, we want you to turn over your forms I-9 in 3 business days, or you can waive that requirement if you want to. And then, oh, here's an immigration enforcement subpoena where we're asking you for additional documentation so that we can, 1, see your payroll report, make sure you have I-9s for all employees, and a bunch of other business documents that are needed for their audit. So we did see an uptick in that a little bit sooner than we had anticipated. Chapelle, like you, we thought that there might be those I-9 notices of inspection right out of the gate, and then we didn't have them. And so we thought, oh, maybe not until April or May. They're kind of going to focus on, the easy stuff right now with deportations, the low-hanging fruit. But then starting in the middle of February, ICE did go around and issue notices of inspection to many organizations. We had a lot here in San Diego. There was focus on the hospitality industry, a lot of restaurants, staffing agencies, and janitorial companies is where we saw a lot of activity. We've also seen auditors with ICE just going to businesses and saying, oh, can we have a sit down? I just want to talk to you about your company, blah, blah, blah. They don't have any documentation with them. It's just they want to gather information. So if an ICE agent comes to the organization and they don't have a notice of inspection or a warrant, then you can politely say, no, I don't want to participate. I don't want to talk with you at this point in time. That notice of inspection, though, it's administrative, but it has to be complied with. Then you have where you're talking about, Chapelle, kind of these raid situation or even other types of action items where ICE will show up with a warrant. And this is where companies really need to make sure that they have a plan for those at their quote unquote front desk. What type of warrant is it? Is it a judicial warrant, which means that it's been signed and dated by a judge and an employer has to comply with that warrant? But they can take protections and have training of their employees so they know, oh, is the right company noted on this warrant? Is the right location noted on the warrant? What is the warrant asking for? Is it asking for a particular person, or is it asking to search a particular location at our work site? Is it asking for documents? And then make sure that that scope of the warrant is held by ICE. Employees can, who are dedicated to overseeing this, can make sure that they don't go beyond that. But then there's also the administrative warrants, right, which are issued by the agency itself, and those do not need to be legally complied with. Our recommendation, what we tell our clients is accept that document and then speak to an attorney to determine if this is something that you're going to turn over. One instance we had of ICE asking for personnel records. Who knows what they want to do with those? So a company can either comply if it's in their best interest legally as well, or they can push back and say, no, ICE agent, after we've reviewed this, we really want you to get a warrant. And then that forces ICE to go to the court and the judge in order to prove why it's necessary to have the company provide that information or documentation. So there's a quick summary of a little bit longer than I intended, but just a quick summary of what to expect with enforcements.
I mean, it's so valuable. And I would say one thing that we've been talking about a lot is this has been largely tip-based for years. And just to give employers a sense of the scale of what we're talking about with heightened enforcement here, in 2024, there were 265 reported ICE audits. In Trump's first administration, at the peak, there were 6,450. And I would argue that it's at even increased focus for this administration in the second term than it was in the first. So just to give you an idea of what we're talking about, 265 to 6,450, that's, I'm not going to do the math multiple here, but I think that if you're in one of those industries that, we're talking about hospitality, food processing, staffing, construction, you are at a greater risk for having one of these agents show up at your workforce. And this advice that Kim's giving is something to really prepare your staff for.
Right. And the other thing, Chapelle, is organizations that may be considered a critical infrastructure, right? We're seeing that as well, because that goes along with the national security and national interest arguments that they're making for a lot of these actions that are taking place.
Yeah, absolutely. Great. I'm recognizing time here, so I'm just going to say penalties have also gone up. This actually happened in previous administration, that fines increased like 3 to 4x in a lot of places. So making sure that you're compliant and that your I-9s are where they need to be is a really good focus right now. We'll be talking about heightened enforcement kind of along all of these. So this theme will recur. I do want to talk about AI and fraud vulnerabilities as well. This is a big topic, kind of like coming in with the heightened enforcement and then the rise of AI, like these things coming at the same time. Poor Ben here, who's monitoring our Q&A, I'm pretty sure we've put him on some watch list because we actually had him go out. We did a full webinar about this and we had him go out and kind of test how easy it was to create fraudulent documents with some of the AI tools that are out there. And let me just tell you, it's very easy. In under 10 minutes, you can have a very good looking fake document come in here. This is not a product demo. WorkBright has some document verification and some things we can do to help you catch those fraudulent documents that might be coming in. But we're seeing the rise of AI create fraudulent documents, which can then be used to employ undocumented workers, which if you're not taking your time and being attentive to these changing trends in AI, you can be liable for employing someone that presented a fraudulent document. So there's also data breaches, which are making more sophisticated fakes. Let me talk about kind of the two types of fraud that I'm seeing in here. And then Kim, I'd love your perspective if you've worked with clients that are seeing this other places. There's kind of like two types that we're seeing. The first one is taking real data, so a real something that has an expiration on it, like not a PRC card, but like an SSN card or a green card that would have an expiration date on it, and then using AI Photoshop tools to manipulate the date so that the year is extended. So I'm staying past the date of my expiration, and I'm presenting this document and presenting it as if it was valid, but it's no longer valid. That's type one. Type two is actually changing, again, a real document to have a photo. This is more in the identity fraud category where someone's taking a document, putting their photo on it. And then particularly with alternative procedure, although E-Verify helps a bit with this, they are representing themselves as being associated with the person that does have valid work authorization. So those are the two ways that I'm currently seeing it. Kim, have you run into that or anything else that you've seen with this category?
That's what we're seeing as well, Chapelle. And then one of the other things just that we're seeing is that individuals have really, really good fakes, but they're using the incorrect version of the Form I-9. Or I'm sorry, not the Form I-9, of the green card, of the permanent resident card.
Okay.
So they're using what might be a valid permanent resident card, but they're changing the dates. And it looks really, really good. And then to your point about AI, Homeland Security investigations, when our committee met with them, the acting chief did say that AI and these fraudulent documents have gotten so good that even some of the auditors and agents cannot detect the difference just by looking at them and feeling them. So it's become a lot more difficult. And as you mentioned, it's a little bit more rampant right now.
Yeah. And I do think we're going to talk about E-Verify here in a second. E-Verify helps with this, right? E-Verify is a good backstop to some of the fraud that's happening. It's not going to catch all of it, but it can support some of these processes. So we'll talk about when it might be a good idea to use that if you're in one of these industries that is maybe more susceptible to fraudulent documents being presented. It may be worth, and we'll talk about when to maybe voluntarily chose to do E-Verify versus not in a future section. Also, increased complexity because we have increased ways to complete Section 2 of Form I-9. So, you know, most of you said you were at a 200-300 level, so you understand Section 1 is employee, Section 2 needs to be completed to validate the work authorizations that are being completed, either by someone internally in your company or by someone that you've designated as being appropriate to fulfill this method. Now we have alternative procedure as well. As of 2023, we have alternative procedure in there. And one thing I just want to say, because I'm still seeing this. So alternative procedure is using a video to do a virtual review of work authorization documents. This was introduced during COVID times as being compliant. They said you're going to have to reconcile these with physical inspection. They kept kicking that date out. Finally, in May, they said, this is really it. You need to have all of those reconciled by August. 10 days before that deadline came up, they said, well, we recognize that employers were using this because it was beneficial to their organization, and a lot of companies are maintaining their remote status. So we'll allow a version of alternative procedure to come in. I think that's great, right? I think it's the federal government recognizing that there's a need, particularly in remote environments, and that physical inspection is a burden for some employers. However, I'd say the guidance was a little less clear. So for those of you that were unclear, even if you did virtual review during COVID times, now that they're allowing it, you would still need to redo that inspection, even if it was another video review, which is only eligible in certain instances, which I'm not going to go down. So just know that if you did virtual review, just because they're allowing virtual review now, does not mean that those are now compliant. You do need to reinspect all those I-9s. And we're still getting a lot of customers that are saying, oh, I'm fine, or I didn't reinspect those. And I do think that you need to really pay attention to that if you're using that process. So Ben, you had a quick poll on here just so that we can understand how much to talk about all these things. Let's pop that up. There we go. Like, what method are you using so that we can talk about some of the differences in these? And then there's also some specific stuff to states. So Kim, one that I think is really interesting just to illustrate how complex this is, the authorized representative network. So some people use an authorized representative with a network. Oftentimes that network is a notary. A notary, so the question that I'm forming to you is, I get questions from customers in California specifically that say, I can't use the network or an authorized representative because I'm in California. That's actually not correct. Can you tell us about the Notaria California exceptions and who can and can't be an authorized representative in California?
Yeah, so in California, there was some concern several years ago about notaries, where individuals might think of a notary as what they think of abroad, which is a notario, who is acting like an attorney. So there were a lot of foreign nationals that were, and even individuals who were taken advantage of by notaries in California. So the state wanted to make sure that that didn't happen, right? So one of the things that they did is they distinguished and said a notary, right, which with the I-9 process, they're not verifying the form, they're not stamping the form, they're not putting anything on the form, they're acting as an authorized representative. Well, in California, unless that notary has specific certification, they're not permitted to act as a notary for I-9 purposes because of the whole mix-up and the issues that we've had in California before. So in California, an individual can act as an authorized representative. That's permissible, but when it comes to a notary, they have to have specific certification in order to do that because of this California law. So it's always a caveat to be careful when using notaries. It's not that they can't be used, it's that they can be used as long as they're that they have certain certification.
Yeah, thank you. And I think that that's just such a good example of some of the complexities here. Authorized representative, it has been, I'm looking at the poll results here, it looks like 61% are still doing that physical in-person inspection in office. that is a great bar, but there are reasons why authorized representatives are more advantageous for speed and throughput and ease of getting people's work authorization documents kind of cleared before that first day of work. What I'm seeing that's interesting here, only about 14% of individuals currently leveraging alternative procedure. And that's likely because to leverage alternative procedure, you also need to be using E-Verify. And there's a bit in the language here that's interesting of this of you need to be in good standing with E-Verify. What does in good standing mean? Is kind of loosely defined. So I see why people are hesitant to this. But as we talk about E-Verify here in a minute, I do think with current administration, there's going to be a push towards E-Verify in some states. And so employers that maybe wanted to use or think that it'd be good for their business to use alternative procedure, but haven't done it because they don't want to go on and E-Verify, that dynamic could be changing. And I think that we'll see a rise in popularity of alternative procedure as E-Verify gets potentially mandated for more employers across the US. So this is kind of what I'm seeing. Kim, would love to see your perspective. Like, there was something that came out, last thing we'll talk about on this one is USCIS for the first time last year came out with guidance for employers that are using software vendors in the space. And I think there's just like a misconception that, well, my payroll platform has an I-9, so it must be compliant. You were giving me a good example. I don't want to name any names here, but like, what are you seeing with some of the things out there that could just help guide employers to say like, hey, let's look out for these things, or here's something to think about with your current vendors?
Yeah, so when an employer is looking to utilize an I-9 software vendor, right, they want to ask certain questions. We say the more you ask questions, the better, because you are responsible for the ultimate compliance. And USCIS, as well as Department of Justice's Immigrant Employee Rights section, has said employer is ultimately liable for anything that happens that comes down with errors on the Form I-9 or discriminatory practices, period. So an employer needs to be really careful. For a long time, like a lot of employers say, no, we're good. This form is fine. It's pretty easy. We've got it under control. And now we've been receiving a lot more questions about, completing the I-9s, et cetera. And one of the things that just recently came up is a situation where the I-9 was being completed, the individual, the foreign employee does not have a social security number yet because they just entered the US in a valid visa status, and it's going to take them some time to get their social security number. For this particular system does not allow the process to go to Section 2 until there's a social security number. So the company is having what they're doing as a workaround is printing the I-9, completing it manually, doing I hate to say it, an e-signature, and then just scanning it and saving it, which has so many issues from a compliance perspective, to the point where CIS and ICE can determine and in fact find that I-9 is non-existent. So it's really, really important to do due diligence to understand not just completion of Section 1 and Section 2, but what happens as you move through the form, as well as with re-verifications, et cetera, just to batten down the hatches, right? If we're going with the sailing theme, batten down the hatches and make sure that the system that you're using is compliant. And there are so many weird, intricate issues that can come up that the guidance from the government really isn't complete. We've been pushing for better guidance for, 11, 12 years now, or a little bit longer. So it's really good to work in conjunction with a really good system and an attorney to understand and make sure that you're compliant.
Yeah.
So yeah, it's really important.
Yeah, and let's dig into a little more of understanding how we're compliant. I think that we've probably scared people a lot with these first three sections. So let's talk about a couple of mitigation plans. I do want to say WorkBright has recently rolled out a audit service where we can take I-9s that were completed outside of our platform, use OCR technology to lift data off of them and run them through what we call like a lightweight audit, right? Like it's never going to be as good as Kim, an immigration attorney, getting eyes on every one of your I-9s, but this can really help employers see if there are pressing issues with the common things that we see. And for everyone on this webinar today, we're offering you guys to do 100 free I-9 audits in this way, so you can kind of see if you have any issues there. But talking through like an action plan, first thing here I'm going to say is evaluate your I-9 processes. Like, love to see, like I said, these general counsels getting involved, and you should be reviewing your process. Kim is the one that I adopted this language from you, always like thinking of an internal memo, like a process that is documented, that can be referred back to, as to here is why and what we do through our I-9 process is something that every organization should have. And right now is a great time. HR professionals, I feel so passionate about helping you guys advocate for your budget and your position within the organization as being so important. This is a great one to get your CEOs, your executive suites involved in, because there is huge liability in this process and they're going to be worried about it. And it's a great way to bring them into what you're doing and how important it is. So anything that you'd add there and just like evaluating and documenting your process?
I always say you really, really need to have that process documented and make sure that you, as an organization, are following that process consistently. And from a business operations perspective, right, it's always, we only have so much in the pool, and we need to focus on where are the big risk issues. And for many, many years, I-9s weren't really a big risk issue, but under Trump 1.0, where, as you mentioned, Chapelle, the notices of inspection increased, it spiked to over 6,000. We're seeing them spike again. But there's bigger consequences this time, where the government is looking for not only, are there mistakes on the Form I-9, but are there undocumented individuals, which if an employer is not enrolled in E-Verify, they might not know that they have undocumented individuals, and then pushing that a little bit further to determine, under an investigation with the company, is there some kind of situation here where the government can say there's harboring going on because a company continues to hire or employ undocumented individuals. So that's a long way of saying, make sure the process is defined and followed, and it's reevaluated periodically given everything that is happening with the government right now, especially with I-9 audits and inspections.
Yeah. And that's a great one into two, which is we are recommending that everyone is conducting an I-9 of not only your process, but your historically completed I-9s that you have on file, whether it's a spot check or a full process. There is a process you need to go through for this. We have some guidance on this. I'm happy to send out. You need to notify your employees it's happening. And most importantly, you need to be prepared to take action if you uncover something, right? If you conduct an audit, you need to know that there could be things coming out of this, and it's good to let your employees know that in advance so that they can comply with what they need to on their end, and you're setting times forward on this. So my little sub bullet in here, I'm going to move on because we need to talk about this, and I want to get to TPS statuses. As you're reviewing these, if you haven't done a great job, make sure you have a document of all of the TPS statuses associated with your I-9s, because this is an area that's changing weekly right now, and you're going to need to be able to refer back and report on those. Last two here, involve special counsel if you find something to know kind of the actions that you need to take. That's a really important one. And then Kim talked a little bit earlier to response protocols if someone shows up, making sure that your front desk staff is trained on these things. So that's a great one to dig into as well. So a couple of tips here for mitigation. But let's jump into E-Verify. First thing that's been coming down is E-Verify Plus. I'll speak to this at a kind of a high level of my understanding of it. And I know not everyone on here even uses E-Verify, so I think it's good for you to know what's coming down the pike, but want to maybe go through these a little faster. E-Verify is a voluntary program. There's around 300 employers that we understand to currently be involved in the beta process of this. And the analogy that I use for E-Verify Plus is it's like TSA PreCheck. In theory, it kind of gives an employee this like status of an E-Verify case ahead, but it only matters or gets applied when an employer initiates an I-9 that can then be associated with it. The same way like a ticket gets applied to your TSA pre-status, right? It still does require Section 2 verification of work-off docs associated with that. So you're still having to do that piece, just like you still have to go through security at the airport, even if you have TSA pre-check. So there's a couple of things in E-Verify Plus. Kim, what's your understanding about it, or anything else employers should know about E-Verify Plus right now?
Yeah, we're really cautious with E-Verify Plus right now because there are some restrictions. There is still an issue with the government agencies working out to confirm that this process is meeting the requirements and regulations for the audit trails. So there's a potential issue with audit trails. And then E-Verify Plus is a system where the government, USCIS, does not store those I-9s. So an employer needs to make sure that they download and they store them properly in conjunction with the appropriate regulations for storage and retention of forms I-9. So it's that step that the employer needs to make sure that they do, because if they don't download them timely, they don't they don't stay there. So they become the I-9s become unavailable, which then puts a company at risk of now not having an I-9 for that particular employee or employees. So it's great that they're moving into something bigger and better. Just be really cautious with it at this point in time, as they actually have said they're still working out like some of the kinks and the issues with this whole process until they get it to perfected. So just be careful.
Yeah, absolutely. Not currently available for employer agents, web services account. If you're using FAR, E-Verify, not available for those. So we'll see. It's kind of very limited right now who's actually on it and using it, but we'll keep an eye on it. And Kim, great point on retention. We had some of our product team on E-Verify webinar about this week. Disappears after 3 days, 72 hours. So if you don't download it within those 3 days, then you're going to have to complete a new I-9, which then of course opens you up to other issues, and it's a great add-on.
Right, timeliness issues, fines, etc.
Yeah. So let's talk about state mandates. Another quick poll here, because I want to understand how deep to go into these. These are my kind of like hot button states right now. California, always a special flower. Illinois has some new stuff happening with E-Verify, Florida and Idaho. So I want to gauge interest real quick in how deep to go into each one of these. At a high level, I'll say it follows the political map. In our more red-leaning states, we're seeing increase of pushing for enforcement and expanded use of E-Verify, and some new bills being introduced to make it mandatory for employers in red states that are not currently have mandates around this. And in our more blue-leaning states, we're seeing additional requirements on top of the federal requirements for E-Verify that employers need to know about and subscribe to. So I am seeing, okay, we've got 54% of the attendees here do hire in California. So it's worth just spending a second in this. And Kim, you live in California. So talk to us for a minute about it's AB 622, right? The additional requirements for California employers with E-Verify. And I'm happy to go into it too if you don't have that readily available. I don't think I prepped too much.
Yeah, if you would start off, I'm just going to look at my notes.
Yeah. So
Yeah.
AB 622 is additional requirements for employers in the state of California. There's a couple of interesting ones in there. You cannot use E-Verify on existing employees. There's notices that need to be given to employees if you want to use E-Verify that are additional, and some timeframes around there. The fines for misusing E-Verify, like not complying with the California, are large. They're like $10,000 plus for each one. So there is no mandate in California. It's a voluntary program. These are for employers that choose to use E-Verify in addition to their I-9 processes. So there's a whole list. It's AB 622. We can look it up and you can go through those. But there may be instances when it may be to your advantage to voluntarily opt into E-Verify. So Kim, I know you're deep in this kind of advising clients. When are you saying like, yeah, maybe it's worth looking at adding this on if it's not mandated for your state?
Yeah, so just to go back to your AB 622, the notices are somewhat similar to what Illinois has done, but they're also similar to AB 450 that California put in place several years ago, which requires notification to employees if there is a notice of inspection, and then every single notice that goes forward in that notice of inspection. So there's some parallels in that of adding additional protections to workers. And if a company has a union, just know that that's something that might need to be negotiated, right? So there are some issues to think of it from that perspective. So some of the pros and cons, right? One of the things with E-Verify for employers is it helps in a situation where with some companies that tend to have a high number of undocumented workers, given this current environment, it might be beneficial to enroll in E-Verify in order to have that E-Verify additional process to determine if those documents are valid within the government system. I know there's all kinds of reasons not to use E-Verify in those industries, and so there's pros and cons with that, definitely. And one of the cons in industries like that of using E-Verify is that you're going to limit your pool of available employees and they might go to your competitors, but that's something to look at. E-Verify also for employers that might be hiring students that are graduating from US universities. There's the STEM OPT extension. that can then allow for up to 2 additional years of work authorization. So that is definitely a benefit to using E-Verify. And looking at it from that perspective, it does cut down on the situation where you find out during a notice of inspection that you have half of your workforce that's undocumented. But one thing I also want to be clear of is that once an employer enrolls in E-Verify, they can't go back and hire their current existing employees. So it can't be used as a way to kind of weed out or determine the work authorization of people that are already employed. So it's as of the date of enrolling in E-Verify, it's going forward. And when using E-Verify, just like any process or system that's being used, document the system and be attentive to that. Make sure that the company representatives that are responsible for E-Verify are in fact following the process. They're staying up to date with what's required, and they are completing the E-Verify for every new employee based on that memorandum of understanding, because otherwise they can get themselves into trouble. So it's think about it, put a plan in place, and then stick to it and be consistent.
Yeah, great one. I'll just hit on these others really quickly because we did have some people that were in those. Illinois started this year. You have a bunch of additional requirements around, as particularly TNCs, I think was the biggest highlight for me out of the Illinois legislation, where if an employee has a TNC, the time with which you need to notify them is reduced from the federal requirements. There's some notification methods that you need to adhere to. So check that out. If you're in Illinois and you're using E-Verify voluntarily, make sure that you're meeting the state requirements in addition to the federal requirements you might be using. Florida has new and expanded people that need to be mandated to use E-Verify. I always think that when E-Verify mandates come out in a state, there's kind of a big splash and a big pull around it. What gets less recognized is when there's modifications to those E-Verify requirements. So now there's more employers that are mandated to use it in Florida. And if you thought previously I didn't need to because I wasn't in that category, that may have changed. So take a look there. And then Idaho has a bill currently in legislation, which is looking like it might get passed, where you're going to have additional requirements as well outside of just the state contractors that are currently mandated. So good states to keep an eye on stuff that's out there right now. And Google Alerts. Google Alerts are a great tip for this. Like if you know you hire in a state that's doing this, look up what the bill name is and then put a Google alert around it and you'll get notified when stuff comes out. That's always a good recommendation for me. This one we can hit on quickly. There's mixed on this. There's been a couple of bills introduced about a national requirement. None of them have gotten very far. I think there's one out right now that has it kind of like baked in deep, but it's not looking like it's going to get passed. We're going to keep an eye on this. I think we're a ways off from having a national requirement for E-Verify, but things have been moving fast. And I do think that to Kim's point about when you use E-Verify, there's flags. E-Verify is a good way for the federal government to get views into what's happening with employment and undocumented workers within organizations. So if they see the national requirement as being something that would be advantageous to things that they're trying to focus on, we could see this speeding up with some different legislation coming through. So, okay, I know we're just about out of time. I want to make sure we're getting to everything. We've kind of talked about action plans in here. Confirm your requirements if you need to be doing this or not. Document your process, especially this thing of like, if you're choosing to voluntarily opt into it, that's like you had your old process, you're writing a new internal memo. As of this date, we are using E-Verify for all employees in this way. You're modifying that and you're clearly demarking the date with which you're putting it in so that in the event of an audit, someone would come in and say, why wasn't this employee verified? Why was this one? You would have the memo to return to say, this is the date that we started there. So document, document, document. And consider if you are in one of those industries that maybe is at high risk and should be strategically enrolling even if you're not mandated. All right, last stop here, TPS statuses. I'm so glad this is one slide. It is changing a lot. Kim, just hit on like highlight maybe a good one for us, like Venezuela or Haiti. Both of those are very interesting. Something that helps employers understand their need to kind of be paying attention to TPS statuses and what's happening here.
Yeah, it's a really good point, Chapelle. With TPS, things are happening pretty quickly, and they already have happened for Venezuela. So Venezuela had 2 designation periods, 2021 and 2023. And then in January, President Biden combined the two of them and then did an extension of both of them until 2026. The current Secretary, Kristi Noem, came in and said, nope, we're not redesignating Venezuela for the additional period of time for those that are designated under the 2023 provision. So from that situation, what's happening is that their work authorization is going to expire on April 2nd. And unless the individual has some other type of work authorization, the employment of that individual is going to have to stop. Haiti, TPS, again, under the Biden administration, Mayorkas extended the designation, and now Kristi Noem, the secretary, has pulled that back in, and so Haiti is going to expire in August instead of the further date. So those are two dates to keep track of, and how employers can determine if they have anybody in that situation is if you have an expiration date report that you pull for your I-9s, you can look at the specific expiration date to determine if that is more likely than not Venezuela TPS or Haiti TPS. And then from there, if you keep copies of the documents, look at the category code for that EAD card so that it gives the employer some reference. And it's something to do, one, not only because you have to re-verify the employment authorization that's expiring, but also from a business operations perspective in order to plan for the potential loss of some of these employees who might not have other alternatives in order to continue to work in the US. And then right now, with those two, there are lawsuits to stop that action that's been taken by the current administration. Stay tuned to see what happens and if that extension of the designation gets brought back. But as of now, we're just planning for April 2nd as the end date for Venezuela TPS.
Yeah, thank you. We could go into I'm going to give high levels, and I just want to acknowledge, look, we're done with this technically at 45. I'm sure people have to break away. We have a ton of really great questions in here. I'm happy. Kim, can you hang on a couple minutes after so we can get to some questions for folks as well? Okay, so We'll get to the bulk of this content, and then just know that we are keeping your questions and we will come back to them. Interesting ones to also keep an eye on here, parole programs. So the Securing Our Borders Act executive order terminated multiple humanitarian parole programs that were out there. This is a big one to keep an eye on. Again, just to the action plan, inventory your workforce. Make sure you know who is here on which protected status. And again, set up your Google alerts. Work with a counsel if you think that this one is in question. A big one right now is the 280,000 Ukraine individuals who are here on a parole program as well. And there's some changes on that we're thinking they may lose their status ongoing here. So these are great things to just be aware of who's in your workforce and then set up your mechanisms for receiving information on that, because it'll come through, it'll be posted on USCIS, but you have to go out and get that information. They're not going to tell you, you have someone here on the status, this person is no longer eligible to work. It's your responsibility to know what's happening and take action with those employees and with all of the grace and kindness that we have for these individuals that have been working with us to support them in whatever that means for them from your side as well. So, okay. For those of you that have to hop off, I just want to get to this and then we'll get into some of the questions that you have. We are recording this. We will send out the slides afterwards. If you'd like to get in touch, Ben, put up that poll real quick. We're happy to talk to you more about this at WorkBright, show you our platform, how we kind of work with some of these challenges and things in here. Also, if you have specific questions, I highly recommend Kim and her team at WR Immigration. They're in this stuff all the time and can answer very specific questions about use cases you have as well. So I'll leave this poll up for a second and let's jump into some of the Q&A. All right, if I'm, in this case, Tennessee, but let's say we're an employer that is based in a place where E-Verify is mandated, but I employ employees nationwide, what are my E-Verify requirements and how do I segment those if I want to do E-Verify or not for different workforces?
Yeah, so best thing is to consult with counsel to make sure it's being set up properly, but you can have it set up so that you're only conducting E-Verify of those individuals that are going to be employed in the particular location and state that is requiring E-Verify. So you can break it down from that perspective, but make sure E-Verify system doesn't make it very easy. So you need to be careful about it.
Yeah, and I would just like lean into understanding what's available in E-Verify as well. Alternative procedure is a great example of this, where alternative procedure needs to be offered to all of your workforce so that we're not discriminating and giving certain people ways to complete I-9s that were not other ones. There are some use cases and workarounds that you can do in that, using hiring sites in E-Verify to say where you are and aren't using it. So really getting familiar with your E-Verify setup and the state mandates that you're in. Because if you're a nationwide employer in Tennessee, but you're running E-Verify for employees in Illinois, you are still subject to the Illinois requirements for those employees that are being run in that state. So nationwide employers need to be paying attention to all of this and making sure that they're compliant within the states that you're hiring on as well. Okay, so if we're using E-Verify, do we need to see and inspect the original document, or is the online inspection enough?
If we're using E-Verify, so if you're using E-Verify and you want to take advantage of the alternative procedure, you have to do that virtual review of the forms, the documents with the individual. And the individual has to provide their documents digitally first. The company rep will take a look at them, and then you set up that meeting. That employee holds up the document or documents for the representative to review. If the individual says, oh, sends in their US passport, and then they lose their passport between the time that they submit that and the time that they're doing the virtual review with the company representative, then they need to start over again, provide additional documents, and then do the virtual review. So that is required.
Yeah, awesome. Thank you. Let me just go through here a little bit. What would you say, like, just summarize again for me, risk if a company is in a voluntary state and they want to use E-Verify versus not? How do you, I think, walk back through that risk assessment that you have on voluntary opt-in to E-Verify?
So voluntary, you need to look at making sure that you're in compliance with a memorandum of understanding that you sign with DHS and SSA, that you have a dedicated individual who's going to be able to timely submit those E-Verify cases, right, which is by the end of the 3rd business day, and ensure that you are E-Verifying all the new hires as required. So it's really important that if you are in a voluntary state, that you follow the guidance of E-Verify and you are consistent. And then those voluntary states as well, like we said, Illinois has now a notification that needs to be provided to employees that's slightly different than the federal requirement. So you also need to stay on top of the state requirements, which who knew that we would be getting into more state laws related to the I-9 process than federal laws, but that's some key things to think about.
Yeah, and are you seeing maybe an increase, because that all sounds like a lot of risk. The pro on this would be if you are hiring workers in industries that are traditionally targeted for workers with documents that may not be valid, there is potentially an advantage to using E-Verify, which is you're going to be under additional scrutiny, and this is going to help you identify those workers. So what are you seeing as like the advantages to voluntarily enrolling in E-Verify as well?
Oh, so those advantages, right, is you can have a greater understanding and relief, if I can use that word, that the individuals who are being employed are going to pass that DHS or SSA test with their documentation, so that it's not 100% guaranteed, but you know that those individuals that you have hired have work authorization to work in the United States, as compared to if you're not enrolled in E-Verify and you're looking at the documentation. As we said, these green cards, employment authorization documents, even social security cards can be, faked. And there are some really good ones out there. So a company might be in a situation where they get a notice of inspection. They're like, hey, we completed our I-9s, everything looks great. But then they come back with a notice of suspect document showing that 30 to 50% of the workforce is not authorized to work in the US because their name didn't match up with the information in DHS or SSA's database. So the E-Verify provides a little bit more protection to help an employer with hiring those individuals that only have authorization to work in the US and are not undocumented. So that's one of the benefits. And then, as I said, one of the cons to that is you might have a smaller pool of candidates to choose from. But there's the risk versus let's just hope we're not audited by the government.
Yeah. And, a big shift that Kim and I have been working with customers on is last year, the big focus from audits that were coming in and different questions about I-9 processes were on, are you creating an undue burden in your responsibility for certain types of workers and documentation, right? It was a discrimination focus previously. Now it really is an immigration focus. So this is where I think some of the people that maybe previously weren't voluntarily opting into E-Verify are now looking at it again and saying, if this is the focus, then I need to make sure that I have the relief of the additional checks that E-Verify is providing. So that's some of the calculation. Okay, quick one here. Can a representative that's not part of your HR do the I-9 instead of your HR team? I'll answer this one quickly. Yes, authorized representative has been in place with I-9 since I think the 70s. So this has been a part of the I-9 processes for a long time. It has been not widely adopted because it's difficult to verify whether that process actually happened. If someone from your HR team is not doing it, how do we know that the individual that is completing the I-9 is that it actually happened and that they knew what they were doing and then looking for? Software vendors, again, not a demo, can really help with this. We in WorkBright provide all the protections around 2 unique IP addresses, the training of that authorized representative. So really drill in on that, but you can leverage that, particularly for remote employers. This is a big focus. Okay, I'll do one more here, and then I know we have other specifics. We're happy to follow up with those. Give us best practices for correcting Form I-9s if you find errors on those. What's your recommendation on correcting errors that uncover during an audit?
Yeah, so if you have handwritten I-9s, right, if you're using the old school method, which works for a lot of companies, any corrections that need to be done, if it's on section 1, they can only be done by the employee. So it's really important that an employer knows section 1, only employee can make those corrections. And then the employee has to initial and date those corrections. And the date is the date that they actually make the correction. Section 2 can only be touched by the company representative. And again, that company representative has to initial and date those corrections that are being made. So if it's on a physical piece of paper, one of the things that makes it really easy for you as an employer, and then if you are inspected by ICE, use different color ink, right? So before it used to be if you use black ink, use blue. If you use blue ink, use black for the revisions. I say just use a green pen or a purple pen or a pink pen or whatever you want so that it's clear that those corrections have been made and that they have been made by the appropriate individual, the employee section 1 or the employer section 2.
Yeah.
Like
and well, just a quick one, like never use whiteout, like don't conceal. I've worked directly with customers on audits of things inside of our platform, and I'll just say these are people, right? Like the auditors are coming in, and if you have made good faith effort to identify errors, make corrections on those, you're going to be viewed in a much more favorable light than if it looks like you were trying to conceal an issue in here with erasing and doing different things on those. So be honest, document why it is, and that's going to go a lot further in an audit than, again, trying to conceal anything. So I'm always recommending that. Just
right. If it looks sloppy, that's okay. The whiteout is not going to help you.
Yeah. And the additional note section is great. And auditors are going to be more friendly when you say, I made all these corrections because I did an audit on my own ahead of this, and here's what I found. That's going to go a lot farther for you. So find out what's wrong on the I-9s, make the corrections, and then you'll be off. All right. Well, thank you guys for hanging out a little longer. Kim, thanks for extending with me a couple of minutes. A lot of meaty questions in here. We are here to answer additionals, and I'll get to some of these very specific ones in like an email follow-up as well. So thanks for joining us today. We appreciate you being here.
Thanks so much.